The other one we're going to talk is a trust-centered estate plan. And if you've seen some of our other information, we've talked about basically that there are two different types of trusts. We're really going to talk about the living trust, which is a revocable trust. There are also irrevocable trust planning tools that we use. Those are not ones necessarily that we're going to use for ourselves during our lifetime. We will use them under certain circumstances, and sometimes we are going to want to transfer assets that way, either for asset protection purposes. We're not really going to talk about that today, but certainly we can talk about that more at another time. We will be doing another talk about those kinds of things. But the trust-centered estate plan, this is really becoming the new, I hate to say the new normal, but I think the majority of people who at least own property and have a certain level of assets, and maybe they have real estate, maybe they have more than the minimum amount of assets, which would allow an expedited probate. So maybe if they have, it's $65,000 currently. So if they have more than that, then they're going to make some decisions. And a lot of people will choose a living trust centered estate plan. So just real briefly as an overview of that, if you don't recall what that is, essentially what it does is it creates a trust, which is a separate, it's not really an entity, we think of it that way, but it's really a special contract. The trust holds the assets. Actually, the trustee is the person who manages the trust. They hold the assets legally on behalf of the trust. And then they have certain rules that they have to follow and certain ways that things have to be done, and how assets are distributed to the beneficiaries. So those are the people who receive the benefits of those assets in the trust. So when we look at our diagram here, again, don't get too drawn into it, but basically, you note here is that we can put assets into that trust. So we can retitle our assets, and it's not a very complex process at all, but we can retitle assets such as our investments, our bank accounts, even our real estate, other property. We can put personal heirlooms or personal property and other heirlooms, various things like that, into that living trust. So that's really good. One of the really good things about it is we put it in there, and it is basically, when it's a revocable trust, you can use it while you're still alive, and you can basically use it about the same as if it was still in your name. The titling is a little bit different of it, but the nice thing about a revocable trust, a living trust, is that you can, because it's revocable, you can terminate the trust at any time, you can change it, you can put assets in, you can pull assets out. You are generally going to be the trustee yourself, the person who's setting up the trust. You're also going to be the beneficiary, and you can continue to make changes throughout the remainder of your lifetime unless you become incapacitated. Why is that important? Well, if you become incapacitated, then we have a successor trustee who can then step in, and they can then manage the assets of the trust. They can do, based on the rules that have been put in place, what we decided in the drafting of the trust, that those things they can now take care of those expenses, various things for you. If you then regain competency, then that's great. You can then take over again. Sometimes people get to a point, especially as they get older, they say, I don't really want to have to deal with any of this. I'll remain as a co-trustee, or maybe they'll even get pulled off, but they'll want a child or children to take care of it. And you don't even have to use a family member, although it's usually often a family member, but you can also use banks and that have trust departments and various things like that. Now, one of the nice things that happens with the trust is when you pass away, any assets that are in the trust, because you don't actually technically own them anymore, it's owned by the trustee of the trust. What happens then is they don't have to go through probate. So you've just avoided all that probate costs that would be involved otherwise. It's also harder to challenge the terms of a trust. So if we have heirs who are not happy about what occurred or what they're getting or not getting, it's a lot harder from a legal standpoint for them to challenge. Not impossible, but it is a lot harder. You can also, you can leave these assets to your beneficiaries in the trust, but you can then go further, and you can also create asset protection for them, because we can then turn it over to them in the form of an irrevocable trust that maybe they can't put assets in now, but creditors have a lot tougher time getting to it. What type of creditors? Well, certainly if there's a lawsuit or something, but also, future ex-spouses. So if you leave assets to your children, and one of your children then gets divorced, if they get them outright through a will, then those assets, arguably, that future ex-son-in-law or future ex-daughter-in-law may be arguing that they are entitled to some of those assets. We can use the living trust to then transfer to a different type of trust when you pass away to that child. And then if they get divorced, which sadly it happens 50% of the time or more by most estimates in this country, if they then get divorced, what happens is you've now protected those assets. They've never actually owned them because they've been in this special type of trust, which we're not going into all the details today about. But you can protect those assets for your family. You can also put certain guidelines on them if you want things to be, for your grandchildren to go to college or whatever things you want to do. And those are all things we can discuss more at a later date. So that is how a trust of that type works, in that type of estate plan. Really, as we look at things, we feel that for most individuals that come to us, that a trust-based or living trust-based estate plan is often the best way to go. It usually they're able to accomplish their goals, do everything they want or need to do in it, and they can protect assets for their children. They can protect against incapacity when they're alive, so that those things will be taken care of. There's a whole lot of more information obviously involved in things, and I wanted to keep this kind of short. So, and we can always talk more, we'll do more talks, etc. But I wanted to kind of go over that. So essentially though, I would sort of wrap this up a little bit by saying, look, the benefits of a properly drafted estate plan is there's a lot of benefits. If we don't do anything, then if you have minor children, there's a problem. Nobody's designating what's going to happen. So we can designate the guardian for our children, or who's going to control assets that are going to the children. We're going to select who's going to be responsible for administering our estate. We're going to select who the financial agents are, who's going to take care of money. We're going to protect our assets if we're unable to manage them. We can minimize applicable taxes. We can avoid a lot of probate costs and a lot of attorney's fees as well if we've done all this at the front end. And usually it's actually cheaper in the long run because it costs less to set these things up, and things happen a lot more quickly when you do pass away. So it works quite well that way as well. We can protect against creditors for our heirs. We can anticipate other issues that may be coming up, various things like that. And also we can deal with business succession planning. So a lot of people are business owners, or they have small businesses or large businesses or whatever. We can deal with those things there. And that's a whole nother topic, which we won't be getting into today, but that is part of the estate planning process if you own a business. So my next slide isn't coming up. Okay, well that pretty much, oh, there it goes. Okay, so here is our slide. This is just our team here at Rocky Mountain Wills and Trust. We all work together closely with all of our clients, and we keep everything, keep everything kind of in the family, so to speak. Although not everyone here is family, we're like a big family. So just to finish up, I want to thank everybody for joining us. I hope this has been informative. We would be happy, we would very much like to be able to work with you, those of you who have been able to attend, or your friends, family, colleagues, whatever. Don't hesitate to give us a call, because we are here to help you develop your estate plans. And I will tell you also, we are running a special offer right now for those who did attend this, and we would probably open that up if they come to us, if it's somebody you refer to us as well. We have a special offer for them. We're going to do some, because of how important it is and because of the time of year, now's a good time to think about these things. What we're going to do is we're going to discount some of our services. We talked a lot about that and decided that it was a good incentive for people to get stuff done that they know they need to get done, but we have a tendency to put off. So what we're going to do is, if a married couple that has attended this, if you sign up with us, if you go ahead and hire us by January 15th, what we'll do is if you do a will-based plan, we're going to take $250 off of of our normal fees for that. And if you do a trust-based plan, and a living trust-based plan or other, we'll actually take $500 off. If it's an individual, we'll half those amounts. But if it's a married couple, that's usually a lot of the people that we deal with. So there are those things. We're kind of a little bit over time now, so I'm going to go on a little bit longer if you're interested. Just we did have a couple of questions, so I'm just going to answer one or two of those questions right now. If you have any other questions, please go ahead and send us an email, office@rmlfirm.com, if you have any other questions. In addition, certainly we feel it's very important, and it's always a good time to get these things updated, but particularly now as we finish up the year and start with the new year, it's a good time to kind of get things in order as we go forward. So please give us a call. We don't charge for a consultation. We're happy to sit down with you, talk about where you are, even if you have an estate plan that has not been updated in a long time. Please sit down, or if you have any other questions, we're happy to sit down with you, talk about where you are, where you want to be in terms of your estate planning. So real quick, if you would like to stay on, I'm going to answer a couple of the questions we got. We had a question about what happens if my spouse remarries after I die? That's actually a great question. I'm glad somebody asked that, because these are things, we live in a time where there are a lot of blended families. People are divorced or they're widowed, and then they remarry, and there might be multiple children from different families. What happens when then you remarry and then the spouse dies? It can really be a mess, because now you have children who may have different interests because they have different parents. So one person may want to leave a certain amount to just their children because that's how they had those. Sometimes couples will decide that's what they want to do. Sometimes you want to split it all. But if we don't plan it out, then what's going to happen is everything may end up going to that spouse, and then that's the second spouse passes away, and those children may not be as fair to the children from the first spouse, because we don't, could be many years later, all kinds of things could happen, or the assets could be diminished. Through proper planning, we can deal with those issues. Usually it involves using trusts and protecting those assets in various ways, but it's an important issue that sometimes people forget to talk about, or they don't think about it very much, and then all of a sudden there's a problem when they pass away. Another question is, why do I need a will? Doesn't everything just go to my wife or husband? Well, yes, it's true. If you don't have an estate plan, things may go just to the surviving spouse if there is a surviving spouse. But it's not quite that simple necessarily, because again, as I just noted, somebody might remarry. You can't control some of the specifics of it. It becomes a lot more expensive, and in terms of probate and various things like that. So there are a whole lot of complexities, which we already talked about at the beginning of this. So it is really important at least to have a will, and we do not recommend getting cookie cutter wills from online. Obviously, we have an interest in our clients not using those, and I don't deny that, but it really comes from our belief of taking proper care of people. When you get something online and you pay a few bucks for it, you just don't get the same kind of quality. You don't have an attorney who's doing the planning for you or helping you with the planning to get done what you need to get done. So on that note, we are about 5 or 6 minutes over. I want to thank you so much for joining us, and hope you have a nice day. But please don't hesitate. Give us a call, and we're happy to schedule a consult with you. Our email address is office@rmlfirm.com, and our phone number is 720-420-1777. Give us a call, and we're happy to schedule a time to meet with you. Thank you very much, and have a great day and a happy new year.